Namaskar. My name is Joshua Castellino, and I'm the Executive Director of Minority Rights Group International and a Professor of Law. And it's a pleasure to be able to speak to you today in this matter concerning title to territory for Indigenous, Adivasi, and tribal peoples. Essentially, what I want to do with you in this 15-minute slot is to first talk a little bit about the context. Then the vast majority of my presentation will look at case law from around the world, and I want to end with a brief conclusion. So the issue really that arises for forest peoples in claiming their land rights really stems from an inability of states to effectively decolonize colonial laws. Colonial laws brought formal titles to lands in Africa, in Asia, and Latin America, but actually those formal titles disregarded the original title holders, the original occupants, and the original users of the land, namely tribal and indigenous peoples, and in the case of India, the forest peoples that we have who are really the central to this particular case. That failure to decolonize has meant that tribal peoples are unable in a formalized world to produce a title to territory that others find compelling. And the consequences of that means that the forest has often been sold off to vested interests. Those vested interests have often involved logging companies that have destroyed the forests, and they've also been sold off to private purposes, and those have been misused, who have misused the forest. It's ironic now that in an era of environmental consciousness, sometimes tribal peoples who have lived in the forest since time immemorial are considered to be hindrances to environmental protection, when actually the evidence is stark. In the millennia that forest peoples have lived within the forest, you've seen hardly any deforestation. You've seen living in harmony. And in the short period of time in which forest peoples have begun to be dispossessed, the damage has been immense, caused by the proximity of vested interests to state parties who appear unwilling and unable and in a lack of imagination in being able to award actual legal certainty and title to the original inhabitants of the forests. The issue really is well settled now in public international law. There are a number of standards globally that highlight the fact that indigenous peoples and forest peoples have a right to the territory that they have inhabited since time immemorial, and the emphasis and the onus is on the state, who has an obligation to find a way to effectively recognize that. So that's by way of an introduction to set out where the issue lies in the modern context. I want to take you briefly through around 15-20 cases very quickly to show the evidence for the fact that this recognition of title now is accepted globally as a customary norm of international law. We start our journey at the European Court of Human Rights and a number of cases there which have talked about really the notion of the concept of possession. So you often hear this argument that there's a particular way and a particular concept and a particular manner in which possession is recognized. But in a case to do with Portugal, the Matose case, Matose Silva and others case, the court determined that actually there wasn't a particular type of consequence, of title, that would give the indigenous peoples, in that case it wasn't an indigenous people, that would give the community a right to be able to claim that particular title. This has also been reinforced in a Turkish case, Onur Yildiz case, which highlights the fact that there isn't really a particular administrative process that is imperative for a state to insist that indigenous peoples might go through. The issue of a forced relocation has also come up in a couple of cases. Hingtak 53, that was a case against Denmark, and also a Handelsholm a Sami case, Sami being indigenous peoples in Sweden. And in both those particular cases, the issue came up about the extent to which relocation was possible. Now, in both those cases, the Commission actually determined that the fair compensation had been offered to the indigenous peoples, but nonetheless, it did reinforce this notion that it wasn't a particular type of administrative process or document that would grant or show in law the fact that indigenous peoples possessed territory. The journey goes on to a number of other cases when you see some cases that have arisen really in Latin America, where the Inter-American Court of Human Rights has been particularly progressive in recognizing a range of different rights. So to give you an example, the Moivana village case that took place, and this is a case that arose in Suriname, concerned eviction of a population from a forest, again, an issue that is very prevalent in the Indian context at the moment. And in that particular case, it was determined that even though the Moiwana villagers didn't have any piece of paper, any formal title that would show their occupancy of the land, the fact that they could demonstrate through other means that their continued occupation of the land was enough to ask the court to find a violation against Suriname and to return the land and the right to enter the land again to the Moiwana villagers. You have a similar cases. There's a series of 3 cases: the Yakye Aksa case, the Sanhoyam Aksa case, and the Yakmok case, all to do with Paraguay, and all to do with the fact that Paraguay had set up a formal recognition of title process, but that particular process was very complex and hadn't been gone through, and as a consequence of which many indigenous peoples were left unregistered. A particularly relevant case in the Indian context because of the really progressive piece of legislation from the 2006 Forest Act. But of course, the fact that the act was not implemented means that many indigenous and tribal peoples today, Adivasis, who lived in the forest, suddenly find that they don't have a piece of paper. And in those 3 cases, Paraguay was held to have created a formal process, but the formal process was not actually accessible enough to the people who needed it. And so a violation was found. You also had a challenge to this classical notion of what is title to territory in the Quechua case that arises in Ecuador. And in the Quechua case, you have again this idea that formal law across the world seems to have one way in which title is recognized. But that formal way in which title is recognized really comes to us through colonial law. And that colonial law was the one that demarcated territory and started to recognize the possession of one community's rights over another community's rights. But in many parts of the colonized lands, those particular titles weren't delimited. So the consequence isn't that those titles were blank territory, but just that law has been unable to find a mechanism to be able to recognize that particular territory. And I think that Quechua case really highlights this notion that we need to move away from classical definitions or classical understandings of what constitutes a title to a particular territory. And we need to start looking at other means, folklore, evidence, oral testimony that might exist, conversations that might have existed in songs or in poetry. And all of those form evidence for long-lasting title and long-lasting occupation, which law should now find a way to recognize. So the imperative here is the title, indigenous peoples, the forest peoples, the Adivasis, have always possessed the forests. They've always had the right to use the forests. Law has been slow to recognize that particular right. The challenge that you face in India is not to ask the state to give the title to the Adivasis. They already have the title. Law needs to find a way to recognize how that title can be documented in a way to give legal certainty to the communities who live there, but also to guarantee that that land cannot then be possessed by others who seek to intrude it for a variety of different reasons. The idea also in that Quechua case that came up very clearly was that if you are to engage in any process concerning those forests, it is imperative to have a meaningful consultation process. Now that is highlighted in the case, but it's also part of customary international law in a concept that we call free, prior, informed consent. And all of those 4 elements are important. The consent that's gained has to be freely given, it has to be based on full information, and it has to be before the event. And this is the international standard now in terms of the treatment of especially indigenous and tribals and forest peoples and Adivasis among them. If we move then to the idea of violations of the title to territory, in the famous Saramacca case, Suriname case, which is a particularly progressive case that is worth looking into, and I trust that the Supreme Court will spend a bit of time looking at that case because it is really seminal. But in that case, the Inter-American Court of Human Rights is saying that it's not only enough to have mechanisms in law that promise title. That mechanism has to be delivered in practice. Particularly relevant again with the Indian cases because of the idea of the 2006 Act. The 2006 Act is of international standard. But a failure to implement it essentially means that the state is in breach of a regulation and straight in breach of where the international current standard is. The other issue that's dealt with then in another Suriname case, Castellino and Logonio, was all to do with what constitutes a minimum threshold. So even if you decide that there should be a return and recognition of indigenous title in the forests, what exactly would be the minimum threshold? And the minimum threshold has at least three elements to it. One is the state has to delimit the territory and demarcate the territory. That's one element. So show very clearly what is the particular lands in which the forests, which are the forests in which the indigenous peoples, Adivasis, live. You show it clearly on a map, you delimit it, you demarcate that particular territory. But secondly, that you go one step beyond and have an actual grant of a title. Remember, the grant of a title, mere recognition, not the actual award. The indigenous peoples and the tribals already own that particular land. It's law that has been slow in recognizing it. And I think the third is that you essentially have to protect that particular title against potential all-comers. And this is an issue that is really important in an era of climate change, because you are seeing this idea that somehow the indigenous peoples damage the forest. We need to get indigenous peoples out of the forest. But then what is moving in is vested interests. And we are seeing this in a modern context now with the policies of Jair Bolsonaro in Brazil, which are moving indigenous peoples out, burning the forests down, really with a view to so-called redeveloping them. And that's in a context where we know the damage that climate change can do. And really, Adivasis in India and indigenous peoples all around the world have been calling this out for a long time. Way before the environmental consciousness dawned on the international community, it's indigenous peoples and tribal peoples like yourselves and like others who have been in that situation, who have the know-how and have lived in harmony with nature. You have been calling this out as a violation. It has taken the international community a good 20 years to finally realize that. And it's ironic that in the case before the court today, it's actually environmental activists who are arguing against indigenous peoples when they should know better, because they should know that it's indigenous peoples, forest dwellers, who have been the traditional custodians of this particular land. Okay, so Castellino and Logonio expresses some very clear minimal thresholds. A couple of cases in Africa, and these are cases that Minority Rights Group International, my organization, has been very involved in litigating. In the Enderoy case in Kenya, both these cases arise in a Kenyan context. And by the way, in the Kenyan context, again, the legislation was progressive. There was a very clear push in the new Kenyan constitution to talk about indigenous people's rights and forest people's rights. The two communities concerned, the Enderoy and the Ogiek, have many similarities, and very many similarities to Indian Adivasi communities. But in the first case, the Enderoy case, which came before the commission rather than the court, the commission found very clearly that they had the formal recognition of title, the formal acceptance of title in law is not enough. You've got to find a way to make that particular title real and meaningful and practicable for the people who live there. And exactly the similar situation arises in the Ogiek case, where the court stresses that a return, because the Ogiek have actually also been relocated away from the forest, many Ogiek communities have been moved. In a landmark judgment, essentially from May 2017, the court said that to be able to enjoy the forest means to be able to occupy the forests, to be able to use the forests, and to be able to enjoy the forest. So it's not just some paper recognition. It's actually putting the community back in the heart of the place that they have considered their traditional home over centuries. So to conclude then, essentially what you need in these cases is a legislation plus a process that will give security. What we have in the Indian context is some legislation, a flawed process, and the consequence of which is that many Adivasis are now finding themselves potentially evicted from the forests. It's no point having the legislation, and it's no point having a process that's unreachable. The two have to combine to be able to guarantee legal title. And that, in fact, is the spirit of the 2006 Act. The way in which the idea that this has been pushed down to Gram Sabha and to other levels show it. So the real challenge, and my plea to conclude, is we celebrated Indian independence with great pomp. We celebrated it because it essentially meant freedom from British rule. And that meant Indian organizations and Indian institutions and Indian governance mechanisms coming into force, and that has been celebrated. But actually, in the case of land law, we have made no progress at all. We have simply accepted colonial law, and we have not been able to find imagination to protect the vast majority of Indians, indigenous Indians. We have not managed to find a way to unravel colonial law and colonial title to territory in a manner that gives legal certainty to tribals. And I call upon you today to go ahead and do exactly that. Thank you very much. Dhanyavad.